What makes assisted living facility cases different? Stick around. Hello out there. Welcome back to the Nursing Home Abuse Podcast. My name is Rob. I will be your host for this episode. This week we are talking about assisted living. What are assisted living facilities? Who are the residents there? Who are the staff there? And what makes these cases different from your typical nursing home case? But we're not doing that alone. We have the fantastic trial attorney Parke Morris up in Tennessee with us today to get his perspective on assisted living facilities. But before we get into it, let's dive into the nursing home regulation question of the week. This week, the difficulty level, I'm going to say, is high. I think it's very rare that we have high difficulty level questions, but I'm going to say this is definitely a high one. So if you get this right, give yourself 2 pats on the back and 90 points. Under 42 U.S.C. 483.90E1, resident bedrooms approved or constructed after November 2016 may accommodate no more than A, 1 resident, B, 2 residents, or C, 4 residents. And that answer is B, 2 residents. So any nursing home that was approved or constructed after November of 2016, a typical resident room can't have more than 2 residents in it. And now it's time for everybody's favorite ChatGPT generated nursing home regulation joke of the week. Again, gentle reminder, everybody, that this is AI's attempt to blend humor with the United States Code. So set your expectations to dashed significantly. Gene, can we get the joke?
The ChatGPT generated nursing home regulation joke of the week.
Skynet.
Under 42 U.S.C. 483.25K, nursing homes have to provide appropriate pain management. Why? Because listening to the same old stories at dinner was just not the kind of ache they could cure.
And there you are, folks. Further proof that the singularity is a few parsecs away. All right, now let's get in the meat and the potatoes of the episode. Again, we're going to be talking about assisted living facilities, ALFs. But we're not doing that alone. We have the trial attorney Parke Morris with us. Parke Morris, a former defense lawyer and appellate clerk, now represents families and individuals with catastrophic injury claims, focusing on the long-term care industry for over 20 years. He has handled numerous cases involving stage 4 pressure injuries, severe dehydration, sex assault, elopement, mystery injuries, and medication errors, and often encountering falsified or missing charts. A national lecturer on nursing home and assisted living malpractice, Parke enjoys tennis and spending time with his children and patient wife. And we're so happy to have him on the show. Parke, welcome to the show.
Hey, thanks for having me on. I appreciate it.
So, and I've kind of mentioned this in previous episodes, but it's an issue that I like to have a continuous discussion about. And that is, a lot of times a potential client or a client will call me and say, well, my loved one was in a nursing home and they were injured. And then you look by the name of the facility and you realize it's not a nursing home. It is either an assisted living facility, or depending on what state you are, it's a personal care home or a resident home, something other than a nursing home. And that, to me, it's just a dangerous thing that the public at large, in their brain, everything is a nursing home. So I wanted to have you on today, and because you've got boatloads of expertise in this, is we need to talk about what assisted living facilities are. And I know it varies from state to state, but in general, what assisted living facilities are and why they're different from nursing homes and what makes those cases different. So the first question I want to throw to you is, what is assisted living? Like, what does that mean to say that there's an assisted living facility?
I think that if you look at the foundational definitions of what I'm going to use the term ALF, but that's okay, just because it takes a little bit longer to say it out. But the first thing that you want to look at is, and this is the sort of the essential test that they put over anyone who's thinking about coming into an ALF, is, can they evacuate from the building under their own power. And so that right there is a demarcation line that separates out someone who is bedbound, for instance, and is going to need a lot of assistance just getting out of the building. So it's almost from a fire code perspective as one of the foundational ways that you look at it. And secondly, I call ALFs or ALF cases nursing home light, which is, in general, it's folks who, your classic ALF resident might be someone who had a minor stroke or has the beginning stages of dementia. And so it's not able to, or struggles with the ability to dress themselves, may need some assistance. Often where you really see a lot of folks entering the ALF environment is that they need help with their medications for a variety of reasons. And so when I look at one of these cases, there's pros and cons to them. In all candor, ALF cases make up, and I've never met an attorney who just focuses only on assisted living facility cases because you don't see nearly the volume of them. Where I'm seeing a lot of phone calls is on financial issues with contract issues where a family's kind of gotten screwed over and they've been billed, even though the care's been horrific, and they've pulled the resident out. And this happened to me last week, and they continue to be billed by the month for the services, or they've paid a huge upfront fee. But from an injury perspective, you don't see as many ALF cases, and I think that's partially because it's private pay, and so they're able to hire usually more competent staff than in a nursing home environment. And then secondly, often the people don't need the level of care, and the care that they are able to receive is so basic that usually the facility can provide the care that's requested for the majority. But when you see a bed sore case out of an ALF, that ought to be a gigantic red flag right there. Because for one thing, assisted living facilities are not allowed to accept someone who has a stage 3 or a stage 4, pressure injury, which means that it's got depth to it. That being said, where I tend to, and if it's okay, I'll go ahead and segment it into the next part of that question, if that's all right.
Sure.
Which is where I tend to see these cases arise is, and here's another foundational question, which I always ask is, when I tend to find a successful ALF case, my first question to the family is, what in the world was this resident doing, even being allowed to enter the ALF, that facility? I mean, I had a case where it was an elopement case. And this is where you see also where the ALF may sort of stretch to be able to accept the resident. And then once they get into the facility, they'll improve through therapy or just strengthening. A stroke victim, for instance. I had a case where a gentleman was partially paralyzed and was in a wheelchair. And really, when we first filed the lawsuit, one of our theories is that he should never have even been allowed to enter the facility in the first place for a variety of reasons, including that he just couldn't get out of the facility under his own power. But while he was at the facility, he actually got stronger to where he could transfer out of the bed in a wheelchair under his own power. And we sort of abandoned that theory because at the end of the day, from a pragmatic perspective, we didn't really feel like that was where the power of the case lay to begin with. And it became an elopement case where, as his physical prowess increased, his mental situation deteriorated to the point where he really posed a threat to himself. And so where you'll see these cases arise often, I've found, is where someone, I call it the donut hole, where there's a missing component. When the resident may first arrive, they present in a certain way, and yet they're not going to qualify as a candidate for the memory care unit. And at most of these ALFs, you'll see attached to the ALF a memory care unit or an Alzheimer's locked unit. And those portions of the ALF are actually highly regulated, and you'll see those locked units also attached to a nursing home. And so those are much more regulated, and that really is the equivalent of a nursing home. But in that interim time frame where they sort of pose a threat to themselves from a mental perspective, where they have advancing dementia, but they don't quite qualify for the Alzheimer's lock unit, and there are certain threshold requirements to be able to get into one of those lock units. I call it the donut hole. That's that missing time frame where the facility, the ALF, does not want to let go of that private pay patient who may be paying $9,000, $10,000, $11,000 a month, and yet they're posing a risk to themselves. And that's what we had with that elopement case, where I ended up taking close to 30 depositions on, witness statements from 11 or 12 employees who worked there. And that was a sad case, but one where the facility was repeatedly warned and knew that he posed a threat of escape. He posed a threat of danger to himself. They didn't have adequate staffing, and these ALFs are not really set up to provide the care that nursing can.
So, at least in Georgia, an assisted living facility is not allowed to provide nursing care, direct medical care. Now, the individual residents can get private care, like they can have their nurses come in, but facility itself. So, I think that when you mentioned the donut hole, I think that's one of the major problems of this assisted living is that you have people that are not nurses most of the time. And when they do have a nurse that's like director of clinical services or director of medical or whatever, they don't have their nurse hat on. They'd have their $11,000, a month resident hat on, right?
Yeah.
So they're not doing comprehensive assessments that like you would see in a nursing home. You have non-licensed people that are unable to understand that an individual is in that donut hole. And I think that's one of the at least that I see that's one of the bigger problems. So tell me then, you're talking about differentiators between the assisted living or the ALF and the nursing home. One of them being the threshold that they must meet to even be in there, right? So one of them is being able to leave if there's a fire. Talk to me about that. Like what is at least in Tennessee where you're at, are there any other threshold admission issues?
Really, I got to tell you, for the most part, these ALFs, they're going to take anybody that they can. Now, I've had a couple of cases where someone was in an independent living facility, which then I call it cradle to grave. They had it staggered, sort of like single A ball and baseball up to the major leagues, which would be the nursing home and the lock unit.
Mm-hmm.
And I had a case where when you're graduating from independent care over to the assisted living facility, where I think you need to do your discovery is if you believe that there was a delay in someone entering the ALF, or they should have left the ALF and moved over to the nursing home. What I find is, what we find out is that the facility knew that person needed to move from one grade to the next, but they didn't have an available bed, and they didn't want to lose the resident, to a competitor. But I got to tell you, most of my cases, they'll take pretty much anybody as long as they can figure out how to fudge on the able to leave the facility under your own power. We had a case where they took the position, yes, he wasn't capable independently of doing so, but since we had a nurse on the night shift, or an employee on the night shift who would have been available if there had been a fire, since he had someone there for 16 hours a day who's private duty care, he qualified. And
wow.
That, of course, is not appropriate. But right. Having actually represented two families in a nursing home fire up in Nashville, where 15 people died, I know too well how important it is to be able to have that mobility to be able to get out of the facility in case of a fire. I got to tell you that is, they are not picky. And it was just this last summer we deposed the admissions director. That was a fascinating deposition when you realize that the bonus of the admissions coordinator was contingent upon how full the facility was. Their utilization rate is what they called it. But at the end of the day, it was how many heads are in the bed at midnight. And she talked about the growing competitive nature of assisted living facilities, how it is dog eat dog. And when they get a hold of somebody who's a full pay at $9,000, $10,000, $11,000 a month or more, the client I was talking to earlier this week was paying $13,000 a month.
Wow.
And and they don't want to let go of these folks because they're cash cows.
Oh,
and
yeah.
They don't have to staff them nearly as heavily as nursing homes.
Right.
And once you get in there, they do not want you to leave. So I got to tell you, I don't see uh, barriers to entry, and they will fudge and
Mm-hmm.
push the boundaries on minimal requirements. Um, it,
What is the so you got these people that are, you know, they're just pushing them in as fast as you can because they're worth so much money, but who in your experience, who is the typical individual, who is the care provider, the care professional that gets the individual out of bed, puts them in the wheelchair, you know, make sure that, you know, that if they need help toileting or help showering, doing that, like who is that person in your experience?
it's been someone who has worked in a nursing home environment, and they've been overworked, underpaid. They've normally had, what I have found is that these are the better nursing home employees who like the ALF experience. They're CNAs who are maybe getting a bump in pay, and that they find that the staffing is generally not nearly as involved.
Hmm.
That's what I'm finding. In other words, in all candor, I'm finding in general that the quality that we saw a decrease in this during COVID, but the quality of the individual providing the care in the ALF environment generally is better because it's private pay, and so they can afford above, or they can be more competitive on the hourly rate. So, having done nursing home work for over 20 years and having handled, I generally have at least one open ALF file pretty much at all times.
Mm-hmm.
I just find the quality of the employees in general to be better. What I'm starting to see is a minor league component to ALFs. And what I mean by that is, in the past, they were all sort of premium, high dollar, highbrow, upper middle class families who had their loved ones at these ALFs. Now you're starting to see $5,000 and $6,000 a month ALFs spring up. And the positive, here in Tennessee, you're actually in state court, you're not able to discover the amount of insurance that a company carries or an individual carries for that matter. It's not discoverable in Tennessee, one of the few states that's like that. But the upside when you sue an ALF is that they tend to have adequate insurance, and they don't have an issue with their aggregate insurance tapped out because there's just so many claims. So I like these ALF cases because I don't have to worry about a bankruptcy, usually, which you see all the time in the nursing home environment,
Mm-hmm.
or 20 claims made on a $3 million aggregate. I took 30 depositions in this case. I got to tell you, I was actually somewhat impressed with the sophistication level. And many and there were nurses who were employed there, but many of the staff were very candid with us. Yes, we thought that the plaintiff was had the mentality of a 3-year old, and we told management that he's not an appropriate candidate to stay here. And yes, we were constantly redirecting him, and yes, we were worried about him escaping, and yes, we told management about that. And so I got to tell you, these elopement cases, I've seen several have crossed my desk recently. And one of the things that when we work up one of those cases, I generally tend to draw a concentric 1 mile ring around the facility and deploy my private investigator. And it's shocking how often, if you go talk to local business owners or anybody who has a business and that's anywhere close to the ALF, they will tell you, oh, yeah, we used to have residents who clearly had some dementia issues. He would just show up inside my business. We'd have to call the facility and have them brought back in. These elopement cases are potentially very powerful, and they are classic cases. They highlight all of the deficiencies of an ALF, which is they're not staffed to take care of someone. And then the question becomes, when you have a locked unit that's literally across the hall, why didn't you recognize the need? And inevitably, the answer is we didn't have room at the inn over there, and we didn't want to lose the pay.
So from a broad standpoint, in a typical nursing home case, when you're making an understaffing argument, you can kind of grab the acuity of the residents using the MDS and then crunch your numbers with your little calculator and figure out, here's typically the amount of staff you're going to need. You can't do that with an assisted living facility because there are no MDSs. So can you walk us through, like, what are some of the strategies that you use in an ALF case to figure out what the quote unquote acuity level is of the staff, and then trying to figure out, either through your experts or whoever, how much staff they should have?
All right, so Tennessee's a little bit different, and I got to tell you, having done this for a while, I think that staffing arguments are very difficult for a plaintiff. They are expert, factually intensive, and often the nursing home can sort of shift the playing field, because you can make an argument that when you're looking at staffing, looking at the entire facility is one thing, but you really need to look at the staffing for your particular hall that your resident is on. And there are HIPAA compliant and HIPAA privacy issues to deal with, and it's always a slog. And so in Tennessee, since we're able to talk to current employees, my
Oh,
private
wow.
investigator can talk to, who are not management. And
Mm-hmm.
I've spent the first 18 paragraphs of our declaration is all prophylactic. You know, understand I'm not being paid. I understand this is voluntary. Here's the name of the defense lawyer. I've been given a copy, et cetera. And we make them sign every paragraph in the bottom of the page. But since we can talk to currents as well as obviously formers, the case law in Tennessee allows us to create a subjective understaffing argument where we don't have to go on the objective side. And so we can bring in testimony from people who worked in the same area of the nursing home where my particular client lived, who can talk about it was constantly a battle. And where I find, I tell folks this, anybody who calls me, it always blows their mind. I'll say, let me guess, your dad or mom ended up going to the hospital on Sunday night or Monday morning. And there's a pause, and almost inevitably, 95% of the time, it's correct. And what I find is where the B teamers hang out, who are the B team staffers, is on the weekends and the holidays. This is Memorial Day that we're being interviewed. Guarantee you a bunch of folks are going to be working at that facility who don't want to be there, who'd rather be at the lake or the beach, who have to, who are being forced to work there. And they also are generally unfamiliar with baseline levels for the residents. And so I tell my clients the most dangerous time in a nursing home is Saturday evening.
Yeah.
And if you're going to look to check out a facility on staffing issues, I find that if you simply hold your phone up, you can basically walk into anywhere if you act like you're typing on your phone, and just glide right in, and you can walk into virtually any facility at nighttime on the weekends and check it out and look to see what the staffing levels are before you put someone in there from a prophylactic perspective. But on the back end, we use almost inevitably rotten facilities. We have no problem because there's a huge turnover. So the red flags that I'm looking for is a large turnover in the director of nursing, administrator positions. Often you'll see turmoil right around the time frame when the injury occurred. What I find is, in most injuries, most cases in an ALF are usually incident cases. In other words, I don't see that many bed sore cases. And when you do, that is going to be, or should be, almost a slam dunk case, in my opinion. I've had a couple, and they've resolved fairly quickly, where we haven't gotten down into the weeds. But to be, I guess I'm in a roundabout way, in terms of staffing analysis, is going to differ on each state. But I feel like it's hard. Often the facility says, well, we've met the minimum levels. And it's difficult often because of shape shifting, where it's difficult to pin down where someone was, where they were assigned to at a certain time. Often just finding those employees and talking to them, they're going to give us what we want. Now, that may be different in different states.
No, that makes sense. I mean, like, you're not having to use, like, spreadsheets and stuff. You've got the direct testimony from people that are currently working there. I mean, I'm sure there's pros and cons of the law in every state, but that's definitely a pro for you guys, is that you can talk to current employees. Obviously we can't do that in Georgia. So in the last couple minutes, kind of walk me through, what are some more of the challenges of an ALF case? Like, what are some of the things that it might be more challenging for you than a typical nursing home case?
Well, first of all, you're not going to see the volume because the needs are not as great. where often the difficulty is going to arise is, and certain lawyers rely heavily on state and federal regulations to sort of create their case. I tend not to, and I'm a big rules of the road guy, and so um, where I think you're going to have problems is that they are not heavily regulated, and a fall case in an assisted living facility environment is, in my opinion, much more challenging than in a nursing home case. And I don't, I've never been a huge fan, and a lot of plaintiffs' lawyers disagree with me. I don't like fall cases in general because there's a built-in defense, which is that we can't restrain them, and all we can do is encourage them and try to protect them, but there's only so much that we can do. And so, if someone's suffering falls in an assisted living facility environment, they're not required to hover over the patient or the resident. And so, I think those can be challenging cases in an ALF environment.
Mm-hmm.
Often the charting, there's just not a lot of charting to look at.
Right.
There's just not. And, we have a 1-year statute of limitation here in Tennessee. And so you may end up having to be able to get your merit letter, which we have to have as gatekeeper legislation. You've got to have even finding an expert can be more difficult at times. There's not going to be as many. And there's less boxes to check. There's less paperwork to create, which gives them less opportunity for error. In Tennessee, we're a one-party state, and so I often encourage my clients to go lock in the story I say, turn your cell phone into an expensive tape recorder and put it on airplane mode and go down and lock the story in before the lawyers get involved or the other side.
Right.
And so often I think that just kind of figuring out what happened can be difficult. I think getting a spoliation letter over to the facility sooner rather than later. In our elopement case that we recently handled, we found out that the gentleman who was in charge of preserving the videotape, he said, "Well, I was told by management that you can't have an elopement case at an assisted living facility because we're not supposed to. They're supposed to have freedom to come and go, and so we're not supposed to guard them. So how could you elope from a facility, an ALF, if they're free to come and go?" Now, that was an attractive argument facially until you get a hold of their internal policy, which says there is an elopement policy at all of these assisted living facilities. And the policy says that if you're aware that they've got dementia and that they need supervision, then the definition of an elopement is someone leaving the facility just per se. That's
Right.
and they're required to notify the police over that, regardless of whether there's
Oh, sure.
So
Yeah.
getting those policies and procedures sometimes can help really make your case, but on the front end, it may be more difficult to get a merit letter because you're going to have a whole lot less to work with, which means you're going to have to do a lot of shoe leather, and that can become a lot more expensive than being a desk jockey and looking at an MDS and looking at all of the tools that you have to work with in a standard nursing home case.
Exactly.
I will tell you this: one of the great fears that the assisted living facility industry has is their cases being shoehorned into a landlord-tenant claim, which has attorney's fees on it in most states. There's only one reported case that I'm aware of in the entire country. I think it's out of Wisconsin, where the plaintiff brought an argument that the assisted living facility, basically at that point, there were no services being rendered. They were basically an expensive hotel for the resident. And so the argument made is that the caps in a medical malpractice or healthcare liability action didn't apply. The Landlord Tenant Act, which I think is pretty much got this similar language in all 50 states, something very similar, that was the controlling statutory authority, which had, of course, attorney's fee provision on it.
Right.
And they are scared to death of that argument.
Sure.
They do not want an appellate court sort of set precedent for that. And so if you've got a situation where your plaintiff is not on a whole host of services, it's a lot easier to argue. And I actually, we had an independent living case where we got the trial court judge to agree that it was not governed by the Healthcare Liability Act, and of course we had attorney's fees, which is a humongous tool to force or lever the case up.
Yeah.
that was a case of alarm fatigue where, the resident was required every day to go over and punch a button saying, I'm okay. And if the person didn't punch that button by 10 a.m., they go down to do a welfare check. And because so many people weren't punching the button, they just quit doing the welfare checks. And so she basically was left on the ground for 3 days
Oh,
and became horribly, horribly dehydrated, which we were able to use the sodium level to prove that up on the hypernatremia
right.
um, and the BUN and creatinine. The baseline levels were normal, and then she was in total renal failure from just lack of water. And that was a powerful case. It
Mm,
wasn't an ALF, but you're seeing these independent living are often there on the same campus as the ALF, and an issue becomes, well, was that person really supposed to be in an ALF environment as they sort of grade down or sort of head towards the bottom, which would be the nursing home environment.
right on. Well, Parke, I really appreciate you coming on the show and sharing your perspective on this. I know that we could probably talk for another 6 hours about this, but I appreciate you taking your time with us today.
Yeah, thanks for the opportunity. I appreciate it.
Well, folks, I hope you found this episode entertaining and perhaps educational. Two Tennesseans talking to one another about assisted living facilities. If you have a suggestion for a topic that you would like me to talk about, please let me know. If you have an idea for someone that you would like for me to talk to as a guest, please let me know that as well. New episodes of the Nursing Home Abuse Podcast come out every single Monday, wherever you get your podcast from. There's not a single place that podcasts are delivered to you from that we are not on. So check it out. You can also watch this podcast on YouTube or at our website, nursinghomeabusepodcast.com. And with that, folks, we'll see you next time. Thanks for tuning in to the Nursing Home Abuse Podcast. Nothing said on this podcast, either by the host or the guest, should be construed as legal or medical advice, nor is intended to create an attorney-client relationship between the host or their guest and the listener. New episodes for now are available every other Monday on Spotify, Apple Podcasts, or on your favorite podcast app, as well as on YouTube and our website, nursinghomeabusepodcast.com. Again, that's nursinghomeabusepodcast.com. See you next time.